This amendment includes valuers, investigating accountants and receiver managers in the Australian Financial Complaints Authority AFCA scheme. Bank-appointed valuers, investigating accountants and receiver managers act in a largely unsupervised environment, and misconduct in this sector has been raised in numerous past governments and Senate inquiries. The Australian Small Business and Family Enterprise Ombudsman has recommended changes and so has various other inquiries. If we are serious about stopping white-collar and banking misconduct in Australia, we should support these changes, and we call for your support to do this with us. The problem is that the new AFCA authority, in its current form, will not investigate misconduct by bank-appointed valuers, investigating accountants and receiver managers. The Financial Ombudsman Service, FOSS, will not investigate cases of misconduct by valuers or accountants or receivers, even when the bank is aware that there has been misconduct. AFCA will be the same under the existing proposals. So in some respects, a toothless tiger. As an example, I have a letter from FOSS showing they will not investigate because once the receiver is appointed, it acts as an agent for the company and not for the person who appointed it. So, in other words, the bank could appoint the most corrupt, incompetent receiver and be aware of misconduct and yet be totally unaccountable. The Ombudsman cannot help unless the bank gives the regulator permission to investigate the crime. In the example submitted, Bank West have informed FOSS that it is not prepared to waive the issues that may exist to enable a fresh dispute to be considered by FOSS. So if the bank wants to prevent an investigation, it can do so, a loophole in the legislation. To add insult to injury, if the damage caused by misconduct is greater than the limit of FOSS, it can fall outside the jurisdiction. This limit could encourage greater misconduct. To avoid investigation, a bank or their agent has to do is ensure that they create a level of damage above the limit. With the Bank Royal Commission now underway and further cases of misconduct being exposed, now is the time to strengthen legislation and regulate this troubled industry. The Australian Small Business and Family Enterprise Ombudsman has confirmed in discussions that there is very little regulation on these banks and appointed entities. They admit that in some cases, receivers just refuse to provide owners of companies they appointed over details of their work. They often charge hundreds of thousands or millions of dollars of work with no accountability to what they have done. We have seen cases where receivers have employed the same lawyers employed by the banks to then also act for the companies they are receiver over, a conflict of interest in itself, and then refuse to disclose to the owners and companies what these lawyers have done. I refer to a letter from the Australian Small Business and Family Enterprise Ombudsman to Senator Jane Hume, chairperson of the Senate Economics Legislation Committee, dated the 29th of September 2017. It reads, "Despite the welcome step of establishing AFCA, we believe there are important considerations which are still missing from the proposed authority, namely the role of third-party agents, such as valuers, investigating accountants and receivers, from the jurisdiction of the proposed authority." The Ombudsman inquiry into small business loans reported dated the 12th of December 2016 made a series of recommendations, including recommendation number 613. External dispute resolution schemes must be expanded to include disputes with third parties that have been appointed by the bank, such as valuers, investigative accountants and receivers. Currently, the jurisdiction of FOSS does not allow consideration of disputes between a small business and a third party, such as valuers, investigative accountants and receivers appointed by the bank. The only alternative for small business in these cases is the court system. Yet, small businesses do not have the expertise to challenge banks through the court system. There is a substantial imbalance of power between banks and small businesses. Small businesses do not have the financial capacity to hire expert legal advice to help them with this power. I recommend change, that the Independent External Dispute Resolution one-stop shop, being AFCA, have a jurisdiction to consider disputes between small businesses and banks, where disputes relate to the conduct of third-party appointed banks. This clearly indicates that our amendments need to be supported. The Australian Small Business Ombudsman said many problems identified during the inquiry relate to the conduct of third parties appointed by banks. Currently, there is no realistic way to seek redress for these actions. ASIC does not take action on behalf of individuals, and the court system is not a viable alternative. The lack of accountability must be addressed. The Australian Small Business Ombudsman would support legislative changes to the AFCA to make banks responsible for the conduct of their appointed valuers, investigative accountants and receivers. The LNP have argued that these changes are constitutional. However, the Senate Procedure Office has said they can't see any constitutional problems with this amendment, and they believe it is compatible with corporations law. Also, under Section 51 Heads of Power, banks, financial institutions and service providers are covered federally. We have run this by the Parliamentary Library. They have advised that our amendments is a solution to the issues raised by the Ombudsman, and they cannot see any constitutional reason why it can't work. The government objects to this amendment on the basis that it is unconstitutional. We have repeatedly asked the government to identify any reasons why this amendment may be unconstitutional, and they have failed or refused to clarify these reasons. The only explanation can be in the fact is this amendment is constitutional. This amendment needs to be supported if we want to help those affected by bank misconduct. Given bank and receiver misconduct uncovered by numerous past government inquiries and their misconduct now being revealed by the Banking Royal Commission, we request that Senators support the proposed constructive changes to bring this largely unregulated sector under control. This chamber should take the word of the Parliamentary Library, the Ombudsman and the Senate Procedures Office, ahead of the government, who would rather protect all their banking mates.